Members of Parliament, support staff, radio listeners, TV viewers, all following this meeting via social media, members of the media, persons in the tribune, ladies and gentlemen, good afternoon, and welcome to the continuation of the public meeting number 15 for today, Thursday, May 28th. At this time, I want to give a special word of welcome to the Honorable Minister of Public Health, Social Development and Labor, Mr. Richinel Brugge, and his support staff here this afternoon. We have established a quorum of 10 members. I invite you to stand for a moment of silence. Thank you. I have notices of absence from the members De Wever and Peterson. No notices of lateness thus far. So at this time, I ask if there are any notifications from the floor of Parliament. I see we have MP Lacroes, who has indicated that he would like to speak during notifications. MP Lacroes, you have the floor.
A blessed afternoon, Madam Chair, Lady Griffier, Honourable Minister of V.C, Richinel Brugge, those in the Tribune, my fellow colleagues in Parliament, and all those listening on social media. Madam Chair, Lady, just a notification that MP Ottley is running somewhat late, but he will be in. Thank you.
Thank you, MP Lacroes. Note is taken of that notification. I now give the floor to MP Lewis. MP Lewis, you have the floor.
Good afternoon, Madam Chair. Good afternoon to the Honourable Minister of V.C, your support staff, those in the Tribune, my honourable colleagues. Madam Chair, I would like to notify through this medium, and good afternoon to the people of St. Martin, to the Minister of Rummy, Madam Chair. You have been saved by your coalition, Madam Chair, but the people of this country is still sending me all the garbage and how filthy this country is, Madam Chair. Madam Chair, the coalition should not only save their minister, but I hope that you all are sitting with him and telling him start to clean up this country. Because I've given him 6 more months, Madam Chair, and if nothing is moved, the same motion of no confidence, just the date I'll change it. And I will present it again here in Parliament. It's time to get the work done. Thank you, Madam Chair.
Thank you, MP Lewis. I thank the members of Parliament for their notification, and we go over to the agenda point for this public meeting of Parliament. The agenda point is deliberations with the Minister of Public Health, Social Development and Labor, addressing the recent integrity-related allegations within the ministry, including the request for an investigation by the Integrity Chamber. This document is listed on the IS 919, and it is dated the 2nd of April of this year. This agenda point was requested, in fact, agenda point number 2 was requested by the MPs Ottley, Lewis, and Lacroes, and agenda point number 3 was requested by the members Ottley, Wever, and Jansen-Webster. I just want to remind you, members of Parliament, that, again, as this being a public meeting, the chair can permit interruptions, which is my intention to do. However, I ask all members to observe the guidelines with respect to interruptions. And just for general notifications, please keep them short. You can give additional information to something that has been said. You can ask something, you can make certain assertions with something that has been said, but they must always be brief and to the point. It's not an extra round that we can use during interruptions. So, and of course, members will be allowed 3 interruptions per agenda point, but again, at the discretion of the chair. This meeting commenced on April 7th of this year, and it continued on May 12th. And then For this particular meeting, it's important to know that agenda points number 1 and 2 have been closed, and then we continued with agenda point number 3. I mentioned the topic for this agenda point, and just to recall, on April the 2nd is when we received the request for this meeting from the members Ottley, Wever and Jansen-Webster, with the request that an urgent public meeting of Parliament be convened to discuss the above-mentioned agenda point. The presence of the Minister of Public Health, Social Development and Labour was also requested, and that's the document I referred to earlier, namely IS 919. We started with the discussion on this agenda point on May 12th, and we received at the start of the agenda point from the Minister of Public Health, Social Development and Labour a presentation, and members were given the opportunity to pose questions to the Minister in the first round, and that is when we adjourned this meeting to allow the Minister sufficient time to prepare the answers to the questions posed. So at this time, the Minister has returned to respond to those questions, and I give the floor to the Honourable Minister of Public Health, Social Development and Labour, Minister Brug, to answer the questions posed by the members of Parliament in the first round. But before I do that, I want to make note of the request by the Minister, which I put to the Parliament, to remain seated, and the Minister could explain why, but if there are no objections to that, then we will allow the Minister to. Yes, for MP Durand, for the Minister to remain seated during his presentation, during giving the answers to the questions. And I told the Minister when asked that I'll just put it to the floor, and there are no objections. So the Minister, you may continue, and you may remain seated. Minister Brug, you have the floor.
Thank you very much, Madam Chair Lady. To the members of Parliament, good afternoon. To the people of St. Martin, good afternoon. Madam Chair, I would like to apologize to the people of St. Martin with regard to this situation. As I understand, there are more pressing issues, also as indicated by members of Parliament, that the Parliament can be designated, there are more pressing issues that the Parliament can use during these sessions to address. I am sorry for the role that I am playing in this process. Nevertheless, Madam Chair, here we are. So I will take the opportunity to answer the questions that were posed to me by the members of Parliament. And for the record, I would like to state that I stand firmly by the statements I have made and the documentation that was submitted to the members of Parliament substantiating my allegations. I will first begin with questions from the Honourable Member of Parliament, Veronica Jansen. First question. The example of the stolen car, did that story have to do with Jansen-Webster? Madam Chair, in short, yes. The stolen car story is an example used to explain how the Prime Minister, who is responsible for Jansen-Webster, which is a very critical department within government, that all ministers and ministries are dependent on, is accusing my cabinet member and indirectly my person for not adhering to legislation. While my cabinet requests input from legal affairs, and after multiple requests to respond, the reaction was, I quote, "Please note that the department is experiencing challenges due to lack of capacity. Notwithstanding the holiday period, nevertheless, it is at the discretion of the minister to determine the way forward, bearing all responsibilities for such," end quote. So yes, if I come to you or your department for advice and you do not react despite reminders sent, and only thereafter find it fit to inform me of capacity issues and that I can proceed as I see fit, then shouldn't the consequences also be borne by the one responsible to ensure that the department in question is able to provide the advice and guidance as requested? Madam Chair, that department is is there to protect us as ministers. So when we send them information and put certain indication of how urgent the information is, Madam Chair, we would expect that answers would be given in order for us to move forward so that we know what is the best course of action so that I don't find myself in this situation and no other minister find themselves in this situation. Madam Chair, Member of Parliament Ms. Veronica Jansen-Webster asked how the minister is able to proceed in the absence of the Yea, Z, and Way advice. She further inquired whether there have been instances in which other advices were approved without the review or input of legal affairs. Madam Chair, both I and many ministers before me, including the former minister Jansen-Webster, have approved advices and signed agreement with external parties without first seeking formal input from the Department of Legal Affairs. As such, I do find it somewhat interesting that MP Jansen would raise such a question. Nonetheless, let me reiterate once again that my cabinet did in fact request input from the Department of Legal Affairs. Regarding this matter, a reminder was also sent requesting at minimum confirmation of receipt. Unfortunately, the requested legal input simply never reached us. In addition, Madam Chair Lady, my cabinet and I have from the onset actively sought clarification regarding which advices or contracts outside of legislations are formally required to be submitted to legal affairs for vetting. To date, no clear legal framework, policy, or written guidelines has been provided outlining such an obligation, as no one has been able to give a definitive answer on the matter. Therefore, while legal input was sought in this case, there also appears to be a broader lack of clarity within government regarding when such vetting is mandatory and when it's not. I can state, however, that it is customary practice that within my cabinet to submit all contracts and advices for legal review, whether internally or externally. That has always been our practice and will continue to do so. The following question, if I understood correctly, the Member of Parliament requested clarification regarding which laws the Prime Minister is alleged to have violated in connection with the BIC registration matter. First, Article 38 of the Constitution of St. Martin, which states that ministries are governed by the respective minister. Together with the Leol and the Organisatiebesluit, these laws outline the responsibilities and authority of the respective ministers and their ministries. Second, Article 39 of the Constitution, together with Articles 6, 9, and 16 of the Rules of Order of the Council of Ministers, governs how advices are submitted, placed on the Council of Ministers' agendas, and discussion for decision-making. Lastly, Article 47 of the Compatibiliteit Landsverordening requires a public bidding for government services exceeding 50,000 guilders. In this case, the value of the project involved exceeds said amount. Under these rules, the Prime Minister does not have the authority to reject or alter advices belonging to the Ministry of V.C. or any other ministry, as a matter of fact, while acting in the capacity of Prime Minister. Madam Chair, if a minister is pressured by another minister to change decision points on an advice before it can be placed on the Council of Ministers' agenda, it is simply abuse of power. Lastly, withholding an advice from the Council of Ministers because of personal interest goes against the principles of good governance, transparency, and rules of law. following question. Is there a working relationship with the Prime Minister? Or is this a case now of a breakdown in government? Madam Chair, I have a working relationship with all ministers, including the Prime Minister. Despite what is being played out publicly, the Prime Minister and I still have a working relationship. For example, just a few weeks ago, the Prime Minister requested an advice from my person and that of the ministry as it relates to public health matters. This advice was submitted to the Prime Minister recently. I remain committed to working in the best interest of the people of St. Martin as long as I am permitted to do so. Those were all the questions posed by the Honourable Member Veronica Jansen-Webster. The following Member of Parliament whose questions I am going to answer is that of MP Lyndon Lewis. MP Lewis provided his perspective on the situation, specifically in relation to Article 54 of the LMA, and inquired as to how I perceive and assess the matter. Madam Chair, MP Lewis, Madam Chair, through you, MP Lewis, during your contribution, you referred to Article 54 of the LMA, and you indicated that in your interpretation, civil servants should not have family members contracted by government, due to concerns regarding possible conflict of interest. Through you, Madam Chair Lady, MP Lewis, I understand and respect your position. To be very transparent, before this matter was even considered, discussions were held with multiple legal professionals regarding Article 54 and how it should be interpreted. The consistent feedback received was that Article 54 primarily addressed situations where a civil servant is directly involved in a business themselves, whether as director, employee, or indirectly as a shareholder. This is not the case in this case. This is not the case in this situation. Additionally, when the Department of Legal Affairs eventually provided feedback on the matter, their advice was not that the arrangement was not possible. Instead, legal advice highlighted the potential conflict of interest and advised, and I repeat, advised that additional measures should be implemented to ensure that the process remained fair, transparent, impartial, and accountable. In other words, additional safeguards were required to eliminate any appearance of a conflict of interest. The legal advice did not state that the contract could not be awarded merely because the company is owned by the chef de cabinet's husband. But differently, the Article 54 of the LMA does not mean that ZAR is automatically barred from obtaining a government contract. It just means that additional safeguards or measures must be put in place. It is also for this very reason that my cabinet requested input from the Department of Legal Affairs in the first place. If there had been any intention to commit wrongful act or intentionally bypass the law, we would have never sought legal guidance on the matter. On the contrary, immediately after it became clear through the bidding process who would likely receive the contract, legal advice was requested specifically to ensure that the matter was handled properly, transparently, and in accordance with good governance principles, particularly in light of the concerns expressed publicly and by members of Parliament when the initial contract was issued. Madam Chair, through you, I believe this point is very important for the public to understand clearly. There has been a narrative created suggesting that a contract was awarded simply because the individual involved is the husband of my chef de cabinet. That narrative is incorrect. A bidding process took place. Individuals were assessed. The person who scored highest and was determined to be the most qualified received the assignment. Yes, it is the husband of my chef de cabinet, but he is also this very day the most qualified Saint-Martiner in this specific field and the only local professional with direct NRPB World Bank project experience from inception to completion of the administrative and documentation process attached to these construction projects. These are not simple files. Many of these project documents can exceed hundreds to 200 pages and require extensive experience within NRPB procedures, World Bank compliance requirements, procurement processes, and reporting standards. ZAR possesses years of hands-on experience with these exact processes. ZAR expertise is not based on assumptions or political preference, but on actual technical experience and institutional knowledge developed over time. If the bidding process was reopened today, the same individual likely would, sorry, okay. If the bidding process were reopened today, the same individual would most likely score the highest based on qualification and experience. That is not favoritism. That is simply the current reality and the available expertise locally. The focus should therefore not be on creating political narrative, but on whether the process was transparent, whether safeguards were implemented, and whether the most qualified person was selected to perform the work that was required. Those were the questions from the honorable member. Those were the final questions from the honorable member of Parliament, Lyndon Lewis. I will now proceed with the questions of the honorable member of Parliament, Omar Ottley. MP Ottley inquired whether I had received any prior warning regarding this situation before it arose. Madam Chair, no. The first discussion held with the party board took place in March and April 2025, after the contract had already been issued and the assignment was completed. I will now move on to the question posed by MP Lacroes. MP Lacroes asks whether any pressure or instructions came from outside the ministry to change qualifications or influence who would ultimately be selected for that position. Yes, through you, Madam Chairlady. As indicated during my presentation a few weeks ago, the ministry, along with other stakeholders, including TWO representatives on St. Martin, the SG of V.S.A., and my person, received multiple requests by the Prime Minister to either halt the current TWO big project, to divert from the Dutch condition attached to the funds received, to disregard the compatibility Lansford ordering for public bidding over 50,000 guilders, or to change terms of reference that was already approved by COM, and to change decision points on advice based on personal preference in order for the advice to be allowed to go to COM agenda. Next question posed by the honorable member of Parliament. As it relates to contract regarding the mental health project, did we overpay? Madam Chairlady, through you, absolutely not. And to date, I have not, and despite what has been said by the Prime Minister, up to today, I have not received or have been provided with anything in writing showing that ZAR was overpaid for the contractual services. Madam Chair, I would also like to indicate to the Member of Parliament as well, through you, that I recently got knowledge that that there was additional payment made to the individual by accident, by the fault of the government. Government requested the bank to send over the money. The individual got an email or got a message from the bank requesting permission to send back over the money. That was done immediately. And that information I got listening to a radio interview yesterday. Didn't know about it prior. Madam Chair, the following question by MP Lacroes: was the job done? Yes. A presentation was provided along with both a draft report and a final report containing recommendations, including a SWOT analysis. Unfortunately, to date, most, if not all of the risks identified, even before the assessment was completed, have proven to be accurate. Following question: if I run the vacancy again, will I find someone else who could have done that job better? Madam Chair, lady, through you, Member of Parliament, no. For me, that is the main issue at hand. Considering all the challenges surrounding the NRPB projects that we are all aware of, the significant funds St. Martin has invested into this project, and the limited manpower within both NRPB and the ministry, and especially the time required for another person with a technical background to become fully acquainted with NRPB and World Bank requirements, it would have not been possible. Following question: the MP asks concerning sharing of confidential document. Was this ever investigated? Madam Chair, through you. No. This matter was never investigated. Following question: regarding medical permits that have been tampered with, what do you think the feeling would be today after those letters came out? Madam Chair, through you, I share the sentiments of the MP. This is a very serious matter, and one that certainly does not help the already negative feelings and concerns that some patients and family members may have regarding certain medical professionals practicing on the island. Following question: regarding mental health project, Minister, can you walk Parliament through exactly what happened with this project? What was delivered? How much was spent? Madam Chair, as indicated during the first round of this meeting, different parties were invited to apply for the project, and the most qualified candidate was selected through the process. As requested, a request for legal input was sent to Legal Affairs Department in December, followed by reminders in January. Due to the urgency of the matter and the needs of the project to continue moving forward, a memo was subsequently sent to Jansen-Webster indicating the necessity to proceed despite not yet having received legal advice. Legal Affairs later responded indicating that they had not been able to provide input earlier due to staffing shortage and the holiday period. The advisory process was therefore finalized, and the assignment was carried out for the approved amount under the signed agreement. As previously indicated, the project resulted in different presentations: a draft report, a final report containing recommendation, and a SWOT analysis. I am willing to provide this to the Member of Parliament if so wish. Following question. MP asks through you, Madam Chair, whether government believe anything improper occurred. Madam Chair, as it relates to the position of government, I can only provide the MP with my personal position and the advice that I have sought throughout this matter. I can, however, confirm that no other minister expressed concerns about improper conduct related to this matter besides the Prime Minister. Following question. MP asks regarding allegations about Prime Minister before calls for my resignation, were any institutions such as the Integrity Chamber or SORB formally asked to investigate these matters? Or were you the first one to send all these documents to the Integrity Chamber? Through you, Madam Chair, to my knowledge, I am the only person who contacted the Integrity Chamber, filed a complaint into this matter. It is also important to note that immediately after announcing through a press release that I filed a complaint at the Integrity Chamber, that I received the letter from the board requesting for my resignation. MP, through you, Madam Chair, I reiterate that my intention to reach out to the relevant bodies such as the Integrity Chamber and, if necessary, the Ombudsman, were made clear in my letter to the Prime Minister from December 2025. So it is not because I am in this situation now that I am reporting these integrity breaches. Following question regarding SZV transparency and governance. Can the Minister explain clearly how the interim director process unfold and whether all established procedures and legal advice were properly followed from the beginning to end? Madam Chair, it is important to clarify that SZV does not have an interim director, as the law does not allow the Minister of V.S.A. to appoint such a position. SZV currently has an adjoint director in accordance with the law. As indicated during my presentation, in the first round, upon becoming Minister of V.S.A. in November 2024, I was made aware of a request from the Supervisory Board to the then Minister of V.S.A. to appoint the current adjoint director to the position. Email correspondence between the former minister and the Supervisory Board confirmed the then minister intended to approve the proposed candidate and finalize the process. At that stage, the only outstanding document was the result of the screening process. The cabinet of the former minister had already drafted the advice to appoint the proposed candidate in anticipation of receiving a positive screening result. After the screening document were received in early 2025, I was approached on multiple occasions by the Supervisory Board requesting an update on the finalization of the process. As such, the appointment process involving the selected candidate, which had commenced prior to my tenure as minister, was upheld and ultimately finalized through the COM. Following question. How this would have taken place in other government-owned companies, such as JB or the Harbor? What is the difference? MP, through you, Madam Chair, I would not be able to fully answer that question, as each government-owned company or legal entity operates under its own legislation and article of incorporation. In the case of SZV, it is important to note that SZV is a ZBO that falls partially under the budget of the Ministry of V.S.A. As indicated in my previous response, all legal procedures were followed regarding the appointment of the adjoint director. It is also important to reiterate that the SZV ordinance does not provide the Minister of V.S.A. or the Council of Ministers with the authority to appoint an interim director. The law only recognizes the position of director and adjoint director. Following question. MP asks if I received any complaints from any of the persons mentioned in my response to the board. Has any one of those letters, have any one of those persons filed a complaint against my person? Madam Chair, not to my knowledge. However, let me take this opportunity to apologize to any person whose name were mentioned in the letter that were leaked publicly. It was never my intention to hurt or offend anyone, or for the letters to be leaked. However, I must reiterate that the content of the letters were truthful and supported by facts. Following question. If you could go back in time, what would you have done different? Madam Chair, throughout, I have reflected on this question many times. In hindsight, I would have examined Article 54 more in depth, as it is evident that different stakeholders interpret and apply the article differently. Even during the questioning in Parliament, members expressed various opinions regarding how Article 54 should be interpreted and enforced. To be honest, there are two key things I would have done differently. First, I admit I should have been more vigilant when signing the advice in question. Okay. All right, sorry about that. Okay. All right, sorry about that. Let me reiterate again. Madam Chair, through you, I have reflected on this question many times. In hindsight, I would have examined Article 54 more in depth, as it is evident that different stakeholders interpret and apply Article 54 differently. Even during the questioning in Parliament, members of Parliament expressed various opinions regarding how Article 54 should have been interpreted and enforced. So this one also. Okay. Following, last question posed by MP Lacroes. Lacroes asks, when I found out that I was being set up, why did I stay? Madam Chair, through you. Madam Chair, through you. There's a phrase that I live by that I constantly always use. Evil shall always prevail when good men stand aside and do nothing. Madam Chair, through you, Honourable Member of Parliament, having the background from the Inspectorate of Education, having the background as a VKS officer, having the background as the founder of the St. Martin Food Bank, I have not only seen, but I have experienced what our people are going through, the suffering that families go through in this country. And I have never been one to quit. So for me, giving up, resigning when I've done nothing wrong is not an option. I will continue to work for the people of St. Martin until the day that this honorable House of Members of Parliament decide to send me home. Those were all the questions from the Honourable Member of Parliament, Lacroes. I will now proceed with the questions posed by MP Artwell Irian. Is any other entity currently in possession of the document was submitted to the Integrity Chamber? Madam Chair, From my understanding, the Lands Recherche is in possession of some of these documents through submission by my chef de cabinet. How is it possible for the Prime Minister to prevent an advice from being placed on the agenda? Have you approached other ministers to request their support in having the matter included on the agenda? Furthermore, is there any written correspondence confirming the Prime Minister's decision not to put the matter on the agenda? Through you, Madam Chair, MP, I have tried different ways to get the advice on the agenda. I held different discussions with the Prime Minister. I also officially requested Secretariat to provide a specific law that gives the Prime Minister this power. The rules of order were sent to me with a note stating, and I quote, Article 16 states that the Prime Minister establishes the agenda. Furthermore, the explanatory notes of the rules of order states that the Prime Minister has the authority to determine the agenda, documents that in the opinion of the Prime Minister are not yet ready for decision-making are therefore not placed on the agenda. Close quote. Following this, I also sought external legal advice as to the power of the Prime Minister as it relates to setting the agenda based on the Constitution and rules of order, and was informed that while the Prime Minister has agenda-setting authority, agenda items cannot be withheld for personal reasons. Once it is ready for decision-making, it should be advanced to the COM agenda. As it pertains to your question, if any written correspondence confirming the Prime Minister's decision not to place the matter on the agenda, the answer is no. However, this was communicated to me personally and also directly to a high-ranking civil servant involved in the project. Following question, what has been the response of your party board and party leader to the allegations you raised as Prime Minister? Furthermore, have you received any feedback regarding the matter from coalition partners or other members of the coalition? Yes, I have received correspondence from the board as recent as 2 days ago, refuting the evidence as I expected. Prior to this, there were only verbal discussions refuting the allegation, justifying the Prime Minister's action and questioning what else I have on the Prime Minister. The Prime Minister also joined the board in justifying his action while condemning mine. Madam Chair, this is a difficult situation for many of the coalition. Different persons have indicated their support. Others have questioned how to move forward with the entire situation. Some have provided advice on how to proceed, but yet we are still here. Those were all the questions from MP Irian. I'll now proceed with the following questions posed by MP Duran. MP Duran asks, why I accept the position as Minister of V.S.A. even though the board and the leaders did not want me to become Minister of V.S.A. Madam Chair, the reason I chose to accept position of Ministry of V.S.A. is because I campaigned heavily on social and economical matters aimed at improving the lives of our seniors and most vulnerable in our society. I made a promise not only to the persons that voted for me, but even those that didn't, that if elected, I would make every effort to serve as Minister of V.S.A., especially seeing the result after when I first requested after the first election of 2024 that I was denied. And I worked hard towards fulfilling that promise. In addition, Madam Chair, as an elected member of Parliament, I was also signatory to the governing accord of this coalition together with MP Roseberg and the leader of the party. It is the three of us as signatories who ultimately determine who we support in Parliament for the position of V.S.I. and the Minister of General Affairs, and not the board. Following questions. Do you have underlying documents to substantiate these strong allegations? If so, if somebody is authorized who does not meet the criteria, how is it possible for them to provide care in our medical institution? To you, Madam Chair. Yes, MP. I do have these documents, and they have been submitted to Parliament through the confidential route. As it pertains to your second question, it is not legally possible for unauthorized medical professionals to provide care or act as general practitioners in our medical institutions. Contrary to what the Prime Minister mentioned on the floor of Parliament, Article 3 of the relevant Lansford Ordinance does not give the Minister the authority to grant someone without the required qualification permission to practice as a medical professional or GP. What Article 3 does, it states it gives the Minister the authority to deviate only when medical professionals has all the medical requirements to operate as GP in their own country and only in urgent situations. In the case being described now, the GP in question does not possess the required qualification to operate as a GP in any country. MP, in recent years, the Ministry of V.S.I. did not have a fully functioning Inspector General who is a medical doctor to properly inspect medical institutions, report findings, and take the necessary actions where needed. It is only since February of this year that through TWO project, we have secured an interim Inspector General while we continue to recruit for a permanent one. The interim Inspector General is also meant to assist us in updating and strengthening the relevant legislation and enforcement measures. So in other words, through you, Madam Chair Lady, the situation does exist on St. Martin MP Duran. However, we were very limited in actions that we could have taken against the individuals. However, we are, through the interim Inspector General, we are taking steps towards addressing this matter. Following question. The MP asks for clarity on liability. If something were to go wrong, who would then be held personally liable? Would it be the Minister, the Acting Minister, or the Prime Minister who gave the directive? MP, I fully share your concerns as it relates to liability, the situation where medical errors are committed. The Ministry also takes this matter very seriously. It is for this reason that since July 2025, the Ministry started publicly publishing every decree signed for medical professionals. This is to ensure transparency and to make it clear to the people of St. Martin which minister ultimately signed a decree, especially in situations where a minister chooses to proceed despite receiving negative advice from both the Ministry and the Council of Public Health. It is also very important to understand the role of the Council of Public Health in this process. the council consists of qualified medical doctors who review all applications on medical professionals seeking to practice on the island. Therefore, it is one thing for a minister to deviate from advice provided by the Department of Public Health, but it is an entirely different matter when the minister chooses to deviate from a negative advice provided not only by the Department of Public Health, but also the Inspectorate of V.C. and the medical professionals serving on the Council of Public Health. To answer your question about who will be liable, it would be the Minister of V.C. because the position is not tied to an individual, meaning whoever is sitting in the seat of the Minister of V.C. when a claim is submitted will be the one that will have to deal with that claim. The affected party may also opt to hold the person who held the function of minister and who signed off that specific decree personally liable. It really depends on the affected party and the circumstances. Following question. The MP, through you, Madam Chair,
MP Ottley? Yeah, your amount of interruptions per agenda point, which for every member of parliament is 3, you have used up your 3 interruption possibilities. Minister, you may continue.
thank you. The MP, through you, Madam Chair, would like to receive, 1, an overview of the different instances where this took place. 2, anything that could substantiate such. 3, how the process ended when I returned. 4, what I meant by acting unlawfully in my... MP, through you, Madam Chair, the relevant documents in this particular case were submitted to Parliament through the confidential route. In this case, a specific negative advice was drafted by the ministry, which the previous minister chose not to sign. Subsequently, while the minister was out of office, the Prime Minister requested the advice and proceeded to signing it. Following, the department head drafted a new advice in response to the signed advice and accompanying memo from the Prime Minister. As signing the advice alone would not satisfy all legal requirements. By law, when a minister deviates from the advice of the Council of Public Health, the minister is required to formally inform the Council of that decision and provide motivation. Additionally, one of my policy advisors reviewed the matter and also provided a negative recommendation regarding the document. Subsequently, during the one day I was out of office last year, the Prime Minister instructed my chef de cabinet to gather the advice for finalization. After reviewing the matter and understanding the possible implication related to the accountability in the event that a medical error occurs, my chef de cabinet informed the Prime Minister that while instructions would be followed, she would add a memo to the advice and would not personally draft the decree. She indicated that the Prime Minister or his cabinet would have to prepare the decree themselves. Ultimately, the decree was never drafted and the advice process was never finalized. As it relates to acting unlawfully, the unlawful part, Madam Chair, after 2 ministers did not agree to sign in this advice due to obvious concerns surrounding the matter, the Prime Minister waited until both ministers were out of office before proceeding to sign in the documents himself. Furthermore, by law, no deviation from the advice of the Council of Public Health can take place unless the Council is properly informed of the decision and the reasoning behind it. Something the Prime Minister did not properly ensure was followed in this case. It must also be noted that in addition to this particular matter, there were numerous occasions where I was invited to meetings between the Prime Minister and medical professionals who, by law, did not meet the legal requirements to practice on St. Martin. During these meetings, it became apparent that promises and insinuations had already been made by the Prime Minister suggesting that I would ultimately sign their decree regardless of their legal requirements and establish procedures. Following question. The MP asks if my leader, our Prime Minister, Chair of my board, chose to publicly distance themselves from the airport work permit saga before prior speaking to me. Yes, it did happen. Following question. The MP asks, what happened to the candidate who scored 104%? Through you, Madam Chair, nothing happened to the candidate. No appointment was ultimately made to the position of CEO. Once a complete supervisory board has been installed, a new vacancy announcement will be published for the position of CEO. At present, I am still awaiting the SZV Supervisory Board to propose candidates for at least 3 board positions. Sorry. Following question. Because you did not choose the URSM board preference candidate, do you feel the relationship with the board soured since then? Let me put it this way, MP. Through you, Madam Chair, it did not improve. Following question. MP asks to clarify the statement of the board that my chef de cabinet was acting as minister. Through you, Madam Chair, all members of my cabinet speaks on my behalf when carrying out their responsibility. Within my cabinet, responsibilities are clearly divided among the different cabinet members based on specific sectors and subject matters, which I believe is how most, if not all, cabinet functions. And at no point do any of my staff act as a minister. To be honest, I don't think they want the headache. Following question, Madam Chair. The MP asks whether I receive backlash for meeting and collaborating with members of Parliament on proposal intended to move this country forward. The answer is yes. Backlash was received both directly and indirectly, particularly in relation to the meetings held with MP Lewis and meetings involving MP Duran and MP Lacroes. However, Madam Chair, my response has remained the same and will continue to remain the same. When I look at the ministers and members of Parliament, I do not see coalition and opposition. I see first and foremost St. Martiners who are seeking ways to improve the country. I will continue to work with any individual who bring forward ideas or proposals that I believe are in the best interest of St. Martin and its people. That is why, as a member of Parliament, I voted for the GB motion tabled by MP Ottley to research the possibility of bringing relief to the people of St. Martin, despite him being in opposition. Even after I voted, I can remember MP Ottley saying, "I surprised you vote." Following question. Regarding minister being on a party, which party? What party? How and why would you want to continue operating in that environment? MP, through you, Madam Chair, the feeling and position of the party towards me have become quite clear. However, as a professional who took an oath to serve the best interests of St. Martin, especially our elderly and most vulnerable citizens, I will continue until the very end to pursue open and respectful dialogue with both the party and the party leader. That is simply the type of person that I am. I was elected by the people and subsequently appointed as minister to work in the interest of St. Martin. Under these circumstances, I believe the professional and responsible course of action is to remain in this position until this Honorable House of Parliament decides otherwise. MP, I must also be honest and say that I am concerned about possible retaliation against civil servants who stood up for what they believe was right. That is also something that weighs heavily on my mind when considering how to move forward, and this is one of the reasons, among others, why I am still here. Following question. The MP indicated that Article 54 referred to conflict of interest. He asks if, in this case, the conflict of interest referred specifically to my person. Madam Chair, in signing the contract with ZAR, it was verified through various legal advices that this did not constitute a breach of Article 54 on my part. And following question, MP Duran requested all documentation that could substantiate the allegation in the letter. These were already sent through the confidential route. MP Duran asks if I trust the Prime Minister. If so, do I have confidence in him? Through you, Madam Chair, I am deeply concerned about the actions and conducts of the Prime Minister regarding matters related to the Ministry of V.C. In my opinion, some of these actions are not only improper, but pose serious concerns for good governance and democracy itself. Many persons have asked me why I did not simply resign. The reason is because when we take an oath as minister or as members of parliament, we are sworn, we also take an oath to protect the institutions of this country, uphold democracy, and stand up when we believe something is wrong. As indicated, I am also concerned about the possible impact on civil servants, especially with rumors of retaliation circulating. Quite frankly, St. Martin needs stronger whistleblower protection and safeguard for civil servants who raise concerns or simply try to follow the law. I would hope that all members of Parliament, regardless of political affiliation, also recognize the importance of protecting these civil servants and the integrity of our institution. As it relates to confidence, I believe confidence in government can only exist when there is respect for the law, proper process, and the independence of ministers to carry out their responsibilities without unlawful interference by the PM or any other minister. Given everything that has transpired, those concerns clearly exist. However, despite that, my focus remains to serve the people of St. Martin and to protect the integrity of V.C. To answer the question, I tread with caution. Those are all the questions from MP Duran. I will now continue with question posed by MP Labega. Madam Chair, MP Labega posed 2 questions. However, one of the questions was also posed by another MP, so I would answer that question together with that other MP, if that's okay with MP Labega, through you, Madam Chair. The question that MP Labega posed that I can answer now: what is the status of the situation involving my Chief of Staff? To answer the question related to my Chief of Staff, she has initiated court proceeding against this matter. Once this has been finalized, which hopefully will be soon, we will know how to proceed. I'll now proceed with question posed by MP York. MP York asks whether the minister believes that good governance is solely about legality or whether it also includes the perception of favoritism. To you, Madam Chair, MP York, I agree with your point that good governance is not only about legality, but also about avoiding favoritism and maintaining public trust and confidence in the process. That is precisely why I continue to emphasize that this particular matter should not be viewed as simply someone getting a job because of connection. The issue here was ensuring that the government obtained the best possible service from the most qualified St. Martiner under very specific and challenging circumstances. We are dealing with high-stakes projects, strict World Bank and NRPB procedures, real risk of delays, manpower limitation, and the unique operation realities that have existed within the NRPB process from its inception. Under those circumstances, qualifications, technical experience, and institutional knowledge became extremely important. The individual selected was not chosen because of personal relationship, but because he was obviously the most qualified candidate during the bidding process and remains to this day the only St. Martiner with direct NRPB World Bank project management experience from the beginning stages to the completion of the required administrative and documentation processes. And again, this is exactly why input from the Department of Legal Affairs was requested immediately after it became clear who would likely receive the contract. If there was any intention to improperly favor an individual or bypass proper procedure, legal guidance would never have been sought in the first place. The request for legal advice was specifically meant to ensure that the process remained transparent, properly handled, and in line with good governance principles. So while I fully understand the concerns surrounding perception and conflict of interest, I also believe good governance requires government to ensure that critical projects are handled competently, professionally, and by individuals with proven experience necessary to protect the country's interests. Following question asked by MP York was also to provide documentations and evidence of allegations that have stated against the Prime Minister. That was already done through the confidential route. Following question, MP York asked whether I am only coming before the House of Parliament because of the situation in which I currently find myself in. Through you, Madam Chair, Chair Lady, MP O.E.C, as minister, I firmly believe that from the very beginning, I followed every possible internal steps available to me regarding this matter. On multiple occasions, discussions were held directly with the Prime Minister concerning the proper legal procedures and processes that needed to be followed. Some of these discussions even took place in the presence of representatives from the government of the Netherlands. Because the Prime Minister had first approached them on the matter, in fact, that is how the ministry itself initially became aware of what was transpiring and of the request to bypass Article 47 of the Accountability Ordinance, which requires bidding process for projects exceeding 50,000 guilders, as well as the strict conditions attached to the agreement with BZK. Additional discussions also took place in the presence of the SG of VSA. Beyond that, I brought the matter to the attention of the Supervisory Board, the party leader at the time, and coalition partners. It is important to understand that it is important to understand that by December, the situation had escalated significantly. At that stage, emails were being sent to the Netherlands suggesting that I had agreed to deviate from the established process, something that could have potentially put millions of guilders intended for St. Martin at risk. There was also the issue of an advice from the ministry being withheld from the Council of Ministers' agenda because the Prime Minister's preferred candidate did not receive the assignment. Most concerning to me was that I was being asked in writing to disregard the entire bidding process and approve a specific candidate. I was also made aware that the SG of VSA had been approached with the request to adjust the TOR, or the terms of reference, so that the individual in question could meet the criteria. For me, Madam Chair, that crossed the line, many lines. That is precisely why, in December, I formally informed the Prime Minister through a memorandum that if the advice was not promptly placed on the agenda, I would report the matter to the Integrity Chamber and the Ombudsman. So to answer your question directly, MP O.E.C, no. I am not only addressing this matter now because of the situation I currently find myself in. I have been raising concerns internally for months and made it clear to the Prime Minister as far back as December that I intended to formally report the matter if these actions continued. And quite frankly, I believe that is the main reason I am here today. Madam Chair, those were all the questions posed by MP O.E.C. I'll now continue with the question posed by MP Roseberg. MP Roseberg asks, what my response would be if in the end it was determined that wrongdoing was committed, and what action, if any, would be taken. From day one, I have consistently stated that I do not believe anything was done with malintent. Input was sought from the Department of Legal Affairs, and action taken were done in what was believed to be the best interest of St. Martin. At the same time, I have also made it clear that if it is ultimately determined that there was a clear and purposeful attempt to commit wrongdoing, then the appropriate measures would be taken. And I stand by that position. MP Roseberg, also MP Lebega, asked a similar question. How would I see myself continuing to function as minister if my party no longer have the trust in me? And how would that benefit St. Martin? Through you, Madam Chair, the same way it has been working from day one, MP. Regional Brook remain one of the signatories to the Governing Accord and Governing Program, both of which outline the important priorities and commitments to the people of St. Martin. In the same way that I have worked diligently from the start to execute those priorities and collaborate with the Council of Ministers, including the Prime Minister, I will continue to do so in the interest of country. The reality is that I have been operating under difficult conditions from the very beginning. However, despite those circumstances, the work of the ministry has continued. Policies have continued to move forward. Collaboration have continued to take place, and the people of St. Martin have continued to be served. All I have consistently asked for is the opportunity to perform my duty as minister without interference, without abuse of authority, and without attempt to undermine the functioning and the decision-making process of the ministry. Madam Chair, one thing that I believe has remained consistent throughout my tenure is my willingness to work with every member of parliament, every minister, and every stakeholder, regardless of political affiliation, whenever the matter at hand was in the best interest of St. Martin. It had my support, and it will continue to have my support. For example, Madam Chair, vaping has been an issue very close to your heart, and immediately efforts were made within the ministry to prioritize and address that matter. MP Roseberg raised concerns regarding possible additional support and funding for meal programs connected with the Ministry of Education, and the collaboration was immediately pursued. Minister Tacklin requested collaboration on matters related to mental health, and I immediately agreed, because mental health is an issue that requires collective efforts beyond politics. MP Duran's motion regarding funeral assistance was also immediately taken into consideration and incorporated into the draft financial aid decree. Likewise, when MP Ottley submitted amendment related to labor permit legislation to the SER, and the ministry was contacted for feedback, my position was clear. Where there are opportunities to work together in the interest of the country, those opportunities should not be blocked because of politics. When MP Lacroes also reached out regarding assistance and collaboration on issues of spaying dogs from a public health perspective, I once again engage on the matter because these are real issues affecting the community. And whenever a member of parliament or colleague minister has reached out regarding a patient or family member potentially needed additional support or intervention, I have always tried to assist wherever possible within the framework of the ministry and the law. So to answer your question directly, MP, yes, I do believe it can continue to work because my approach has never been centered on political division or personal conflict. My focus has always been on policy execution, collaboration, and delivering results for the people of St. Martin. At the end of the day, ministers do not serve political parties alone. We serve the people of this country. And as long as there remains an opportunity to continue implementing the governing program, advancing important policies, and working together in the interest of the people, then I believe that the work can and should continue. That is how I intend to continue governing, through collaboration, openness, professionalism, and focusing on results. The people of St. Martin expect maturity, stability, and cooperation from their leaders, especially during difficult times. That has always been my approach, and that will continue to be my approach moving forward. Madam Chair, I have come to the end of all the questions posed by the members of Parliament. However, Madam Chair, can you allow me 5 minutes? Let me just regroup. I have additional statements I would like to make as well.
So, Minister, you're asking for 5 minutes, and then you want to come back and give some concluding remarks on this point. Let me allow you to do that because the members still have, based on your answers, the possibility for clarifications. So I want to inform the members, I'll allow you your 5 minutes. We come back to clarifications, and then, members, we will adjourn so that we can caucus about the way forward. And I say this because you might be aware of the fact that we received additional confidential or additional information to be considered confidential from the Minister of V.C. Subsequently, a file of information from the Prime Minister to be considered confidential. So, following the minister's adjournment, or the adjournment for the minister, clarifications, the Parliament shall adjourn, and we will discuss how further based on what I just mentioned. So with that, I will now give the minister 5 minutes adjournment, and then we will come back at 4:56½. Meeting adjourned. Members of Parliament, ladies and gentlemen, welcome back to the continuation of this public meeting of Parliament. We are discussing with the Minister of V.S.A. matters related to that ministry, specifically integrity matters, as requested by members of Parliament. So the meeting as requested by members of Parliament. The Minister has just responded to questions by members of Parliament in the first round, wishes to now add a few additional comments to those answers, which I will allow the Minister to do at this time before I go over and offer the members of Parliament the opportunity for clarifications. So that's how this meeting will proceed, and I now give the floor to the Minister of V.S.A., Minister Jansen-Webster.
Yes. Thank you, Madam Chairlady, for allowing me that brief recess. I had some technical difficulties. There's a document that was missing. That's why I actually wanted the extra time. In ending the answering of the question, I would like to make the following statements. Public service is not always easy. There are moments of criticism, moments of pressure, moments where one's character and intentions are questioned, publicly and personally. Yet, despite the challenges, I remain committed to serving the people of St. Martin with dignity, resilience, and integrity. Difficult periods do not define a person. Rather, it is how one responds to them that truly matters. I therefore choose to remain focused on the work and the people we serve and the responsibility entrusted to me. I am grateful to those who have continued to offer support, prayers, and encouragement during these times. Your faith and confidence are deeply appreciated. No matter what obstacle, I believe that the truth, fairness, and preservation will ultimately prevail. Madam Chair, again, despite the challenges and the things that we're going through right now in this country, and I stated earlier, I do apologize for my participation and my involvement in it, but I do believe I'm standing up for justice, for what's right. At the end of the day, I still see a way forward without obstructing or interfering or making life even more difficult for the people of St. Martin. I still see a way forward. I have not given up, and I will not give up. And I'm hoping that the powers to be, those individuals, would also see things my way. An example was given to me by one of the very close friend. He said this is like a bad divorce. And I heard MP Lewis also stated the children are suffering. Madam Chairlady, I also believe that even in bad divorces, you have ways to settle the matter without endangering or harming the children. That is the option that I'm looking for. That is the option that I hope that each of us that have a stake in this would take. So thank you very much, Madam Chairlady. I'll now wait for any clarification questions.
Members of Parliament, as I mentioned, you now have the opportunity for clarifications based on what the Minister presented in terms of answers or statement. The first MP to have the floor for clarifications is MP Veronica Jansen-Webster. MP Jansen-Webster, you have the floor.
Thank you, Madam Chair, and good afternoon to my colleagues. Good afternoon to the Minister and his support staff. Madam Chair, I had noted 11 questions, and most of my questions were not answered. I would like to get those answered. I started, Madam Chair, with requesting the Minister to pull up the slide, and I then gave a summary, and I asked the Minister if he could confirm that indeed he had indicated I have here, is it correct that shortly after the minister took office in November, advice was sent to Jansen-Webster regarding a contract for the Chief of Staff's husband, and that that contract was signed by the Chief of Staff as early December? So I asked the minister to confirm that that was the situation that was sketched in that part of the presentation. I went on, Madam Chair. I also asked the question if the analogy of the car, if that was Jansen-Webster, and that one the minister answered. Oh, this one. What urgent circumstances justified hiring the Chief of Staff's husband without waiting for the advice? Because the minister had indicated in his presentation that there were 3 reasons why he had to proceed without awaiting an advice. And I asked what were those 3 reasons. And I remember stating that one of the reasons that I did have a chance to note down was that there were funds that needed to be secured. And I had indicated that, to my knowledge, funds were already secured, and that the minister had indicated during the budget presentation that those funds were secured. So I said, what were the other 2 reasons at the time? I didn't get an answer to that one. I also asked questions about why names of people were called, but the minister apologized for that today, so I don't have to get an answer to that one. I asked why was MP Jansen-Webster described as having personally appointed an individual when, according to me, the appointment followed a board recommendation. And today again, I heard in an answer to another MP about a URSM preferred candidate, and that is where I would like to know, did URSM have a preferred candidate, and if yes, who was that? I asked about what specific law the Prime Minister allegedly broke, and that one was answered. And I also asked those were the ones that were not answered. Then additionally, for a clarification on something that the minister just mentioned, where the minister mentioned, through you, Madam Chair, the minister mentioned that he has up to date not received anything that SAR has been paid more. But when the minister says he did not receive anything, did he request it and it was not received? And the minister mentioned that he only heard on the radio about a double payment, and that the payment was made by government, was a double payment. But I also listened live to that radio program, and I heard where the host mentioned and acknowledged, yes, indeed, 14,000. And then my question then is, because, I mean, initial question was, did the minister go and look to see what the double payment was? And since he found out now via the radio, when I heard the 14,000, when I do 83,000 minus the 48,510, I don't really come up to 14,000. So I think it's important, and I don't know if the minister thinks it's important as well to find out then what was actually paid to that consultant. So those, Madam Chair, were my clarifications based on what I had asked and the questions that were never answered. Thank you.
Thank you, MP Veronica Jansen-Webster. Does any other member require the floor for clarifications? I see that is the case, and I give the floor to MP Doran. MP Doran, you have the floor.
Thank you, Madam Chair. In response to one of the questions that I posed, the minister said he will tread light. Well, Madam Chair, I too will tread light because I believe that some of the information heard here today, even the other day when the Prime Minister was here regarding the medical professionals and qualifications, quite disturbing. And the reason why I touch on the fact that it's quite disturbing, because, Madam Chair, these are persons that are supposed to prescribe medication to you, supposed to treat you when you're ill, maybe even operate or do certain procedures. And if the Prime Minister, Dr. Luke Mercelina, who is a medical professional, states that 5 or 4 out of 19 GPs have proper qualification, Madam Chair, God help us all. Madam Chair, based on the question that the minister responded to, he mentioned also that the Prime Minister invited him to meet with a group of unqualified medical professionals. I would like some clarity on that point. Because what was this meeting about through you, Madam Chair? Was this meeting about how they can get qualified, or was it about approving ways and means so we could put more unqualified medical professionals in the field? Madam Chair, when the minister mentioned about retaliation on civil servants, I would like some clarity on that. Is it the case that you fear if you move from being the Minister of V.C, that the persons within the Ministry of V.C that spoke up or gave any sort of substantiation to the points that you brought forward in terms of the allegation, will they be targeted? And lastly, Madam Chair, I talk about the liability. I think I could speak for almost everyone in here, which I am not doing, when I mention that I believe everybody in here experienced some sort of medical situation, whether directly or indirectly, that they were not too pleased with how the situation was handled by medical professionals. Madam Chair, if you tell me, not you then, the Prime Minister is telling me that we have 15 unqualified medical professionals out there, then I think the people have the right to know who these unqualified medical professionals are. Thank you very much, Madam Chair, and I look forward to the Minister providing that clarity, albeit confidential, and also a plan on how we're going to get those unqualified persons qualified, because I am extremely worried when it comes to our medical situation based on those statements by the Minister here today, and more so those of the Prime Minister. Thank you very much.
Thank you, MP Duran. Members, any other clarifications needed? Yes, I have MP Lewis. MP Lewis, you have the floor.
Thank you, Madam Chair. Madam Chair, I'll use this moment to tell the Minister thank you for responding to my question, even though I still differ in opinion based on the article that I mentioned, because it also not only talks about the civil servant, but also their spouses, okay? I did listen to the good gentleman on the radio. I did follow what he said. And I also look at my St. Martin people. If the person is also qualified for the position, in order to move this country forward, then so be it. Because a lot of our own people are put on the back burner when they are qualified or they study and they can't come back and get no job, etc. But once it's for the beneficial part of this country, I stand by it. And I also reflected, because everyone knows I too was a minister and part of the same council of ministers. And I can recall also at one point, the good Prime Minister did ask me for support on something. And I later on learned that the individual, because I didn't know, I didn't have any knowledge, that it was his first cousin. So sometimes when I sit back and I reflect on these type of things and see certain things happening to the contrary and we want to question integrity, these are the things that we're supposed to talk about. Thank you, Madam Chair.
Members, just a reminder, we are in the round of clarifications, so you would ask the minister to clarify something that he said or brought forward. Yes, we have other clarifications, and the next member of parliament to make use of this opportunity is MP Erin. MP Erin.
Thank you, Madam Chair. Good evening, all. Good evening, Minister, support staff. Minister, my first question would be, ask for clarification then, based on the answers you give. If you could have done anything different, if you could have gone back in time, January would you have done anything different? That's my first question to you. Would you have done anything different? In addition to that, you mentioned that you answered one of my questions and said that different solutions were provided under, I guess, the party. I guess it was, I'm assuming, the party board or members of the MPs or members of USM. And I asked also, was mediation suggested? So was there a mediator involved? I also asked the Prime Minister. And if so, what? I think that's a question I asked also. So if there's a mediator involved between the party to resolve this situation, and what came out of all of that? Thank you, Madam Chair.
Thank you, MP Irian. MP Duran, I'll allow you the opportunity to ask one more clarification question.
Thank you, Madam Chair. Just so the last question that I brought up could be clear, I want to give an example so that the minister, so we don't have to do much back and forth. Let's say, for instance, unlike many other countries where the family suspects foul play or malpractice in the death of a family member, and does the family have to pay for the autopsy? Because we've heard about different cases in St. Martin where some of us have experienced where we see our loved one here today, they go to the medical center, they are diagnosed or misdiagnosed, you go home and they pass away shortly after, young, healthy individuals. I don't want to go into the exact example, but I would like to know, with all these unqualified doctors that you and the Prime Minister, through you, Madam Chair, are mentioning, how do we as a population know to test the waters and know if something went wrong? We don't see the doctor's qualifications as if when you go in a supermarket, you would see the Chamber of Commerce registration, you'll see everything from a business perspective. How do we know, how can you safeguard us as citizens in this scenario? Thank you very much for the opportunity, Madam Chair.
Thank you, MP Duran. We continue, members of Parliament, with the clarifications, and I give the floor to MP Ottley. MP Ottley, you have the floor.
Thank you, Madam Chair. Madam Chair, if you allow me before my clarification, because news travels fast and far. So let me start by saying St. Martin has some of the best doctors. St. Martin do have some of the best qualified doctors. But the reality is there are those that are unqualified, as you heard from the Prime Minister himself, and that operate. I have one clarification through you, Madam Chair. The doctor that you spoke about, Minister of V.C., that was not only not qualified to work in St. Martin, but not qualified to work anywhere. Is this the same doctor that the Prime Minister override the department and approve because he said, through you, Madam Chair, that he knows her? I want to make sure if this is the same person. I hope to God not. And I also asked the Prime Minister if you were consulted, so I'll ask you, were you consulted before overturning this decision? Thank you, Madam Chair.
Thank you, MP Ottley. Are there any other clarifications to be asked from the Minister? That does not appear to be the case. Members of Parliament, I am going to adjourn this meeting. And of course, I'll take into account when the Minister can come back. There are questions to be answered, which he has to do. However, as I mentioned earlier, we have a set of documentation received from the Minister regarding this meeting, and the documents received confidentially from the Prime Minister also refer to statements made in this meeting. I am going to actually consult with the Minister and the Prime Minister on this matter. While these documents have been submitted to be handled confidential, fact is that any statements derived from those documents made in here by members of Parliament or ministers, you can't be prosecuted for them. So which would mean that information can be gleaned from those documents and used in here and put forward in here. And I want the Prime Minister and all ministers, in fact, to understand that very carefully. We're now talking about issues like medical professions. We are talking about doctors that look after patients here on St. Martin, talking about some of them being qualified, unqualified, but yet, I guess names cannot be divulged. Do we recognize what signals are being sent to the population of St. Martin? For this reason, members of parliament, this meeting shall be adjourned because I believe this discussion needs to be had, The rights of the members of parliament will be respected. We will continue at some point, and answers must be provided. But I will not have this meeting continue under this cloud. The documents are available. Members have the right to peruse them. But until, together with the members of the government, we can establish a modus operandi for these type of matters, because I get a feeling more and more that where this discussion is going is not good, again, towards the population of St. Martin. It has nothing to do with the issue of integrity or not, who right, who wrong, who did, who said, but we're now talking about understanding that some medical professionals who are responsible for the health of our community, that some of them might be, and we're using words like qualified and unqualified. Maybe it has to do with registered and unregistered or not yet registered, but fact is that's the picture that is being painted out there. So members of parliament, Minister, you have taken note of the clarification questions. I see all MPs who have actually asked for the floor. I'll allow you under the, like, sort of a proposal of order, make a statement or ask a question, but I have indicated and which members of parliament I have the right to do given circumstances in a meeting to do this. So I'm just making that clear. So that is not a question that I put, but I will allow those members who ask to do so to make a brief statement, again, given the circumstances. I'll start with MP Franklin Myers.
Madam Chair, good afternoon to my colleagues. Mic check. Good afternoon to my colleagues here in Parliament, the Honourable Minister of V.C., his support staff, those of you in the Tribune, radio listeners, and those of you watching via social media. I want to echo the statements of MP Ottley because bad news travels far and quick. I like that statement because when the word unqualified is thrown around, in certain cases, maybe not all cases, in certain cases it has to be taken into context. And for example, the very doctors that we may be referred to by our local insurance here to go to Colombia for medical attention and treatment that treats us would be considered unqualified here based on our legislation. So I think that has to be taken into context, and I think what has to be said is that we have a specific legislation because the doctors that you go to the ENT here, I have a sinus problem, go to the ENT here, but for my surgery, I had, for what I had specifically, I had to go to Colombia. But the doctor from Colombia couldn't come here because he would be considered unqualified. I just wanted to bring that into comparison because it's a legal thing, and some instances it may not necessarily be an actual qualification thing. Thank you, Madam Chair.
Thank you, MP Myers. Members of Parliament, as I said, I will allow members to make a brief statement following what I have indicated. That would be the further proceedings of this meeting, and so I'll continue offering that. Brief and to the point, members, and I give the floor to MP Ottley. MP Ottley, you have the floor.
Thank you, Madam Chair. Madam Chair, I guess we're in agreement spirit today. I have to agree with my colleague on different means and ways of unqualification. Persons that are qualified elsewhere may not be able to be qualified here as good as they can be top surgeons because of our legislation. But the reason for my clarification is specifically the good Minister of VSR said the doctor was not qualified here nor anywhere. That is a dangerous thing that the Prime Minister would still approve such because he knew them. And Madam Chair, I say this again, I want to act publicly then so I know how to set my schedule tomorrow. If we have to see when the minister is coming back, is the meeting then postponed for tomorrow where it states lack of confidence for the Minister of VSR? Thank you.
Thank you, MP Ottley. No, the meeting for tomorrow is not postponed. I continue with offering the floor to MP Lacroes. MP Lacroes, you have the floor.
Thank you, Madam Chair Lady. Madam Chair Lady, I am happy that MP Ottley just asked that question and that you answered it right away. And I'll tell you why. That is unfortunate. Because I'm asked tomorrow to make a decision on something that I now don't have all the facts to, and seems very unfair to my person and to any other MP, I think, right now that wants to make a sound decision on what is actually going to take place here tomorrow on the floors of Parliament. And Madam Chair Lady, this is, once again, I'd say, an embarrassment to the country. I am glad that you have taken the bull by the horn concerning those documents that now lay before you and how we are going to move forward with them. But at the same time, all that guilty need to go home. That is my opinion. Thank you, Madam Chair Lady.
Thank you, MP Lacroes. I continue now and I offer the floor to MP Duran. MP Duran, you have the floor.
Thank you, Madam Chair. I just want to be very, very clear. I am definitely one to be very careful when it comes to protecting information and being very careful with what comes out of my mouth, because I know that my words carry weight, as my colleague always says. But, Madam Chair, these statements derive from the same conversation when I asked the Prime Minister, so I just want the whole public to understand. If the letter has that the person was not qualified and you still push to allow them to work, why was that? The Prime Minister continued to answer and mention because he knew the individual. Secondly, the Prime Minister continued, based on my clarification and interruption, to mention that out of the 19 doctors on St. Martin, the GPs, if I'm not mistaken, is the words that he used, only 4 have the proper qualifications. And that's when I continue to ask if I get some clarity on liability, if it's not the case. Now, I do agree with my colleague, MP Myers, that maybe it's about them not being qualified only here, and MP Ottley, when they qualified in certain areas. But then the minister mentioned that there's one individual wasn't qualified anywhere in the world. So I just want the whole public to know this is not a scare tactic. This is not no political thing, because I have family members that I feel were dealt with in a way, and I would consider it malpractice. But that's my emotions, that's my feeling, until I could prove otherwise. But how would I know? And the Prime Minister, who's a professional medical doctor, is telling me that 15 of them are not. I am nervous when I hear those things, and I agree with you, Madam Chair, to stop this meeting until we could get some clarity. But I just wanted to be very, very clear. This thing have nothing to do with politics. Pure facts based on what the Prime Minister of St. Martin, Dr. Luke Mercelina, mentioned. Thank you very much, Madam Chair.
Thank you, MP Duran. I continue now with MP Lewis. MP Lewis, you have the floor.
Madam Chair, thank you for the opportunity. I will say this. Again, when I sit here, I like to do my research. The Prime Minister did mention about 4 is qualified. I'm here to correct that because I did my research. It's 7 that is qualified. Okay? And that certain doctors did not follow the general practitioner uplading. Okay? So we have to be very, very careful also with what we're saying, again, because you're putting some kind of scare tactics outside. Madam Chair, PM, not you, MP, take it easy.
MP Lewis.
To follow to continue, Madam Chair, again, based on your statements with those documents, I believe politically we're thinking that something is inside that document to the detriment of the Prime Minister. Because if the meeting have to still go ahead tomorrow with Minister Brooke, that is indeed unfortunate and not correct. Because the Prime Minister himself ain't bring no kind of justification with regards to his statements here in Parliament. So, Madam Chair, again, I would like us to review the facts. We're still waiting on the information from the Prime Minister, and going ahead with that meeting tomorrow with Minister Brooke should never be fruitful. Thank you, Madam Chair.
Thank you, MP Lewis. I now give the floor to MP Irian. MP Irian, you have the floor.
Thank you, Madam Chair. Thank you, Madam Chair. Madam Chair, so I got a couple of messages just now, and I think this meeting itself and the Prime Minister also caused more concern to the general public than anything else. And it almost feels one of the messages said that it seems as if we are trying to cover up something, and that's a feeling I don't want to have as Parliament for sure. I don't want it to seem like Parliament is covering up something, especially when it's something to deal with medical and health and so forth. I think it's very important that ministers are aware of the things that they say on the floor of Parliament, on Facebook, and anywhere else. We've seen in Curacao, for example, where a court case was won because of something a minister said on Facebook. And the judge said that what the minister said is just as good as publishing in the National Gazette. So that's how much our words have weight when it comes to being a minister. You can't come on the floor of Parliament and just say something randomly and say, oh, well, it's only 4. No, those were words of the Prime Minister. And those were basically solidified by the Minister of V.C. So I don't want, as Parliament, that we're going to act all hush-hush. No, I think even more so now, thanks to the melee and the infighting of Minister Brooke and PM, that we now getting information out of this. Because if they didn't have their in-between beef, right, we would never know. So sometimes, they say God works in mysterious ways. And I think a lot of people that have concerns, that they are looking forward to the information going forward. Thank you.
Thank you, MP Irian. Members of Parliament, in connection with all that has been stated, I also want to remind you that we have an ongoing meeting with the Prime Minister, who also has to come back on some of the matters pertaining to that meeting. So that be clear as well. Members of Parliament, Minister Brugge and support staff, ladies and gentlemen, this meeting of Parliament is adjourned until further notice. Meeting adjourned.